everything together. Excuse me. All right. Good afternoon, everyone. My name is Soraya Ferdman, and I'm a staff writer and researcher at First Amendment Watch. First Amendment Watch is a news and education site based in the Arthur C. Carter Institute for Journalism at New York University. And this is the fourth iteration of FAW Public Forum, a series of monthly online Q&A with leading legal thinkers on the most pressing topics in First Amendment law. I am so excited to introduce our guests, all of whom have done really amazing research and writing on defamation and media law, and particularly many of the kinds of lawsuits that arise from social media claims. First off is Lyrissa Lidsky, Dean of University of Missouri School of Law, and Judge C.A. Leedy Professor of Law. Lidsky's research and teaching focuses on the intersection of tort law and First Amendment, with an emphasis on free speech issues in social media. Missouri Lawyers Media named Lidsky its 2020 Woman of the Year based on her scholarship, passion for law, mentorship of students, and engagement of constituencies supporting the School of Law. A prominent media law scholar, she is co-reporter of the Restatement of Defamation and Privacy, co-author of leading media law casebook, a First Amendment casebook, and a reference book on press freedom. Before becoming a law professor, Lidsky served as a clerk for the Honorable Joseph T. Sneed on the United States Court of Appeals for the Ninth Circuit in San Francisco, California. Also joining us is Jonathan Peters, a media law professor at the University of Georgia, where he is faculty appointments in the College of Journalism and Mass Communication and the School of Law. He is the press freedom correspondent for the Columbia Journalism Review, and he has written for Esquire, The Atlantic, Sports Illustrated, Slate, Wired, and CNN, so many news organizations. He has also blogged about the First Amendment for the Harvard Law Review and Harvard Law and Policy Review. And he is a frequent commentator on First Amendment issues for the New York Times, the Washington Post, Vanity Fair, CNN, NBC News, CBS News, NPR, and PBS. Peter is a co-author of the book, The Law of Public Communication, and his scholarship has appeared in journals published by the law schools at Berkeley, Harvard, NYU, Virginia, among others. And finally, we have RonNell Andersen Jones, who is an affiliate fellow at Yale Law School's Information Society Project and the Lee E. Teitelbaum Chair and Professor of Law at the University of Utah S.J. Quinney College of Law. A former newspaper reporter and editor, Professor Jones is a First Amendment scholar who teaches, researches, and writes on legal issues affecting the press and on the intersection between media and the courts, with a particular emphasis on the United States Supreme Court. Her scholarship, published in numerous top journals, addresses issues of press access and transparency and the role of the press as a check on government. She is also a widely cited national expert on reporters' privilege and news gathering rights, and a regular speaker on emerging areas of social media law. All right, very long introductions, and sorry, I wanted to make sure we gave full all the background for all our amazing guests. Again, welcome to this FAW Public Forum. We're calling it Reclaiming the Narrative, Defamation Lawsuits in the 2020 Election. As promised, we'll be talking about Smartmatic and Dominion's libel lawsuits against Fox News, as well as their suits against former Trump lawyers Sidney Powell and Rudy Giuliani, and Trump ally Michael Lindell. I think this conversation broadly is also about the current state of our media environment, public and judicial concerns about bad faith journalism, and the particular challenges and risks of using defamation law as a tool to regulate the press. To start off, we're lucky enough today to have both experts and people familiar with defamation law and people less so. I was wondering if Jonathan or Lyrissa, you could give us a quick run through of what a plaintiff has to demonstrate in a libel complaint. Lyrissa, yeah, please go.
Oh, okay. So normally, in order to prove defamation, a plaintiff has to establish that there was a defamatory communication, and to be defamatory, a statement has to be the kind that would tend to damage reputation. So you have to have a defamatory communication. It has to identify the plaintiff. It has to be published to at least one third party, And then what else the plaintiff has to prove depends on whether the plaintiff is a public official, like a government official, a public figure, like a celebrity, or whether the speech involved is a matter of public concern. So oftentimes you will have to prove, in addition to a defamatory communication, identification, and publication, that the person who published the defamatory statement either knew or recklessly disregarded the falsity of that statement. And then the plaintiff mostly has to prove that the statement was false as well.
So emphasis on intentional false claims.
Yeah, sometimes if it's not a public official or public figure, you can prove less. You can prove negligence instead of that intentional or reckless standard. So it's easier for non-public figures and non-public officials to establish a claim for defamation.
And Jonathan, you wrote following both of the complaints, you wrote an opinion piece in MSNBC on how they were presented. What was your immediate reaction to these complaints? Were Smartmatic and Dominion's lawsuits strong claims?
My immediate reaction was that it seemed as if disinformation was being put on trial. The complaint, for example, against filed by Smartmatic, rather, declared, for example, that facts matter, that truth matters, and one of Dominion's complaints says that.
I can't quite hear. Oh, sorry, Jonathan.
Again. Oh.
Sorry, we got up for a second. Can you repeat 1 second?
Oh, sure. Yes. Have I caught up yet?
Yes.
Okay, terrific. Sorry about that. And I was just saying that, one of Dominion's complaints says that the company wants to stand up for itself and for the electoral process. And if you cast these complaints against the backdrop of recent efforts to weaponize libel law for any number of purposes, it could be to generate publicity, to score political points, to exact revenge on critics. Examples that I wrote about in the NBC News piece include Devin Nunes, who has sued all manner of people, commentators and media organizations. I think it's at least eight different complaints filed at this point, including one against CNN for $435 million. One against Esquire for $75 million in response to observations and stories about Nunes. There were complaints filed by Joe Arpaio, the former Arizona sheriff, who sued the New York Times for nearly $150 million over an opinion piece that called him, among other things, it was a sadist masquerading as a public servant. And yet another complaint was filed by Roy Moore of Alabama infamy, who is suing Showtime and Sacha Baron Cohen for $95 million after Moore's appearance on a Cohen show, Who is America, in which Moore is subjected to a fictitious pedophile detection wand. And so, I think that when I think back to my initial reaction to the Smartmatic and Dominion lawsuits, I thought about those other lawsuits because I think that they have either been dismissed or are highly unlikely to succeed on the merits as they go forward. And I think that that's chiefly because they have the look of politically motivated or performative litigation. They involve speech that clearly receives First Amendment or other protections. And then in contrast, I think in large part, the Dominion and Smartmatic claims are more serious. I think they're more meritorious. They involve provably false statements of fact, some of which were made after the defendants were repeatedly notified of their falsity.
Absolutely. Fox News did put out a correction afterwards. That's something they bring up in one of their defenses, that they aired a kind of series of, not the anchors themselves, the anchors didn't personally correct them, but they aired a third-party voting expert that seemingly corrected all of those claims after Smartmatic and Dominion wrote to them. Do you think that's enough, or did that apology come too late? Oh, did I get cut off? Excuse me. me.
No, I
Yeah,
just,
jumping in. Oh, Lyrissa, do you want to take that one?
oh, I was hoping RonNell would take it.
Yes, please.
Yeah, I think that's going to be a really important and interesting question. A big piece of what's happening here is that Fox News is characterizing itself as an even-handed deliverer of the news, and so that evidence that you just described is already something that they're centering in this litigation. There's in the Smartmatic suit, there's a 14-page appendix that is titled something like "Fox's Even-Handed Coverage" or something like that, and it's just a series of moments when the Fox News network characterized something as not yet understood, or as just a claim, or as countered by Dominion or Smartmatic, or as otherwise being contested. Three of the examples are this example that you've described that came after the fact, right? After Smartmatic had already alerted them to the risk of lawsuit and was therefore sort of them scrambling to play catch up. And the footage of it is really interesting to me, and I think is going to be really interesting as a part of this litigation. It seems like a very clear effort to just sort of get on the record a set of corrective facts. It's a kind of almost stilted, formalistic exchange with Eddie Perez, an election machines expert, just sort of asking and answering a series of questions, debunking some of the lies that were asserted by Smartmatic in the suit. And so, so what we're saying is these examples that Fox is putting forward of it having engaged in even-handed dialogue over the course of its coverage weren't in fact all examples of even-handed coverage. Some of them were examples of it responding to the threat of the suit, which I think is going to be an interesting component here.
So if you don't mind me jumping in, so oftentimes a retraction, well, sometimes plaintiffs are required to request retraction before they can go forward with their suits. A retraction doesn't normally negate liability, but it may reduce damages. But in this case, I would say the retraction was too little, too late. The kind of negative barrage of lies had gone on for about a month before they got this retraction, and the retraction was milquetoast. I mean, it wasn't a robust retraction, even if you count it as a retraction. So,
in the sense both that it was not any one of the anchors who had supposed, had presented these claims, and it was a video that almost didn't seem like it was in line with the rest of the coverage. Like it was a kind of alien coming in and announcing it. Yeah, absolutely. I'm curious, RonNell, if you could go back, there's a timeline of and we have this actually in a teacher guide that we have free on our site that we use to teach the Alex Jones Sandy Hook lawsuits, where often a plaintiff says, look, I wasn't sure if these claims are true. I know that I had a duty to investigate whether they were or not. And the way that I went about it wasn't, oh, I believe they're true, but I'm constantly curious as to whether or not I have a duty to my audiences to investigate that. When you look at the timeline, where does that fit in with how they covered, or where are the loopholes in that?
Yeah, so that's right. That is exactly going to be the tension that we see here on the two fronts, and what you see is Fox News characterizing throughout its filings in this case, and I think we're going to see throughout the litigation in this case, really characterizing itself as a deliverer of information on matters of public concern, right? Let's just note here, this is a moment for noting why this is so complex. Because the arguments that both, as Jonathan was sort of alluding to, the arguments that both sides are making here are very much moored in basic democratic norms, right? So part of what's happening on the Fox News side is we respect and value freedom of the press, and we do so for democratic reasons, right? Press freedom enhances democratic self-governance. It's critically important, Fox is saying, that we be able to run news stories and to pass along information on significant matters of public concern. And certainly a president challenging the legitimacy of an election, right, is nothing if not newsworthy. And so that is very much the way that this is being cast, right? This is the framework in which this is being placed. And the converse is also arguments that are moored in democracy, right? False and misleading information, particularly if it's sort of deliberate false and misleading information on questions so central as like the integrity of our ballot boxes, is itself really critical to democracy. And so that's where the tension is going to lie. I think the timeline question that you're referencing is really going to speak to that, right? That's going to be the question of whether the evidence that is presented to the court suggests that what was happening here was a constant seeking of information about this matter of public concern and a presentation of information as it emerged. Reports, right? Were these just reports on filings in courts that and information from attorneys representing a president that needed to be conveyed to the public? Or was there something more, which is the suggestion that Smartmatic is making here? Smartmatic is saying in a lot of places in this complaint, in some very powerful ways, that what happened here went beyond the reporting of information on matters of public concern, the sort of neutral letting us know that a complaint had been filed, to something more. There's aggressive verbs being used in this complaint, right? That they were expressing astonishment, that they were expressing support, that they were endorsing, that they were validating, that they were deliberately spreading things that they knew were false. That's where the timeline is gonna, the timeline and the kind of inquiry that was made, the kind of motivations that existed are going to be key.
Thank you. Yeah, absolutely. Now, that kind of makes me think a bit more of another thing that I tend to hear, which is the expectation that somewhat a personality news person, we are supposed to somehow as readers take or understand differently, that they may speak in more hyperbolic language. They might encourage a guest that they bring on to make more extremist claims, and they themselves might articulate positions that are partisan or are not entirely based in concrete fact. Is that something we're going to see here too? Jonathan, I'm curious, maybe because you were saying that this seemed more like was a more meritorious claim.
I think it could be, and maybe before I address that, I'll underline what I think is the importance of the context that RonNell just shared with us. The First Amendment is, of course, expansive in its coverage. It's rooted in values, that ideas ought to compete with one another for acceptance, that, as the US Supreme Court has put it, that public discussion is a political duty, is a fundamental principle of the American government, as the court put it, too. And so free speech, in other words, it contributes to democratic self-governance. These are the very reasons that political expression receives a great deal of First Amendment protection, arguably the highest form of First Amendment protection. The dominion in Smartmatic complaints, they arrive against that kind of background. And they also arrive at a time of growing concern about the role of disinformation in American politics. And that's one reason that I think that these complaints, should they go to a full verdict, and especially if they would eventually produce a published opinion on appeal, that they could be consequential. Harvard's John Goldberg wrote about these two cases. He said that if some of the defendants are able to resolve these suits with relatively modest settlement payment and with no admission of guilt, then the message might be to other speakers and broadcasters that you don't have to worry that much about defamation law. But he continued, he then wrote that it may be that these suits are reminders that there are some legal lines that simply can't be crossed. So, again, I think that context that RonNell was getting us into is really, really important to keep in mind when we're evaluating the significance of these cases as they go forward. Now, to the separate question that you ask about opinion makers and provocateurs on network shows, So this fundamentally gets us into the First Amendment protection for opinion in the area of defamation. And the Supreme Court has recognized a high level of protection for statements of opinion. The US Supreme Court famously once said that there is no such thing as a false idea, and then went on to say that, however pernicious an opinion may seem, we depend for its correction on the conscience of judges and juries, not on the conscience of judges and juries, but on the competition of other ideas. But it's important to bear in mind that this protection is not unlimited. It has not created, as the court later put it, a wholesale defamation exemption, for anything that might be called opinion. And so in the weeds here, the really difficult thing is distinguishing statements of opinion from those of fact. That context is critical to that enterprise. And so kind of in the abstract, the court has found that some words are so exaggerated and so hyperbolic, or they're used in such a figurative sense that they're not even capable of a factual interpretation. And then the court has also found that opinions implying false underlying facts can be actionable, but that generally opinions based on stated facts, often receive protection because the readers have no reason to think that the opinions are actually facts. They're able to see for themselves the separation between them and the basis of the opinions. But nonetheless, it's critical that all of those types of facts have to be presented accurately and be open to a plausible interpretation. Otherwise, even if a speaker states the facts on which he or she is basing an opinion, if they're inaccurate, if they're incomplete in some way that would materially change the meaning of the statement, or if the assessment of them is erroneous, then the statement could still imply a false assertion of fact. And so, again, courts are going to call on context and review the totality of the circumstances around the statements at issue here. And as I mentioned before, in the Dominion and Smartmatic complaints, some of the statements at issue are definitely provably true or false, or they imply unstated facts, either of which could be actionable. And then once again, just to remind you that a number of these statements were made after Fox News was apprised.
Oh, we lost him. A second. Jonathan, you said, I caught you right before you said and then you had a kind of last string of thought.
Oh, okay. That was the greatest point that I made.
Oh, man.
I don't remember what it was.
Okay.
And
No.
so, I was just saying that, the court here is just going to have to review the totality of the circumstances, and that in the Dominion and Smartmatic complaints, some of the statements at issue are provably true or false, or they imply unstated facts. And again, either of those can be actionable.
Lyrissa, I saw that you had a paper up where you looking at a particular, please go ahead.
So one of the things that's important here is that some of these anchors appeared to fully take on and endorse the claims. Here's an example from Lou Dobbs. Lou Dobbs told his viewers, by the way, the states, as you well know now, they have no ability to audit meaningfully the votes they're cast because the servers are somewhere else and are considered proprietary, and they won't touch them. It won't permit them being touched. All of those are factually false. And the important point is it's factual. Had Lou Dobbs said, oh, the president's lawyers are claiming there's voting fraud in these machines and we ought to listen to what they have to say, that would be opinion. That would be entirely, well, actually, there are even some problems as to whether that's protected depending on what jurisdiction you're in. But nonetheless, assuming it's a jurisdiction that says you can report on important and newsworthy allegations by others, that would be protected. But once the anchors themselves endorse the factual information or even expand on the factual information, that's where they end up being potentially liable for defamation. Because one of the features of the tort is to make sure our public discourse has some necessary anchor in truth.
Absolutely. And there are multiple points, not only where Lou Dobbs and I think Bartiromo says adds to them, so it makes new false claims, but will frequently introduce both Rudy Giuliani and Sidney Powell as truth tellers and thank them openly again and again for bringing kind of uncovered facts to the surface. That's not how I necessarily would address allegations I'm unsure about. Tends to be the opposite.
Well, in the Smartmatic complaint, they point out that they go even further and tell their listeners, don't listen to other sources. We have the truth right here. And they repeatedly use the word evidence, 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 even though Giuliani never produces any real evidence. Or they produce some evidence, but it was evidence that was later discredited by all the courts that they submitted it to.
RonNell, please.
I think it's really interesting because if you read the Smartmatic complaint, there's actually two categories of assertions that are being made here. I would clump one set of them as being assertions about how Fox presented itself, and others assertions about how Fox presented its guests. And both of them are combined in this really interesting narrative about the suggestion that Fox is going beyond bare presentation, sort of bare neutral reportage of what's going on, and instead endorsing, backing, furthering, reiterating, reinforcing the views. So some of those things, as Lyrissa said, are about the sources, right? Emphasizing that these folks are attorneys, emphasizing that they're truth tellers, emphasizing that they have evidence, right? Sort of saying those kinds of things. But some of them are about Fox itself. Fox saying, we're award-winning, we're the only source you can trust, we're the only place where you're going to get this information, we're the only place where we're the only trustworthy source of information about this particular topic. And those two combine in the complaint to be really the sort of baseline for what we're seeing here of an assertion that it can't just be that this is neutral reportage of information that they're just passing along to you, but rather that they should be seen as more involved.
Absolutely, absolutely. And sorry, 1 second. I'm seeing this one has their hand up. Can anyone explain very quickly what the neutral reporter's privilege is? Because I just realized that we've been talking about it, but we haven't actually defined it. Anyone who wants to, Jonathan, or Lyrissa.
Oh, yeah. So the neutral reportage privilege has been recognized by the Second Circuit Federal Court of Appeals. And what it says is sometimes it's newsworthy just that somebody made an allegation, and the press ought to be able to report on the allegation being made, even if they know the allegation is false, so long as they don't endorse it or amplify it. So it requires that you have an allegation made by a responsible, prominent organization, and then that the press neutrally reports on that allegation made, which has to be newsworthy if they're going to report on it, and they can't amplify, endorse, or sign off on it.
And can we note just that the elephant in the room here is that the Trump administration has really brought to the forefront this question, this broader question about what to do about provably false assertions that are made by a person in clear positions of authority like the president. And I think it's really interesting, the overlap between some of the pieces of the conversation that we're having here and what Lyrissa just described as the neutral reportage sort of undertones of this set of cases, with some of the things that were happening in the run-up to Trump's ban from Twitter and Facebook. There was a very long period of time in which both of those social media platforms were saying the president is in fact violating some of our content norms, right? He's violating our rules. He's engaging in behavior that we would, if it were someone else, take down. But we're in equipoise about what to do about it because he's the president of the United States. And the bare fact that the president of the United States is saying this is itself newsworthy, right? Is itself interesting and important, not as a matter of public concern. And it's that same thread, just dressed up in a different way, that is really permeating a lot of these conversations. It's part and parcel of a wider concern about the interrelationship between disinformation, accountability for disinformation, and the informing of the public about the sources of those disinformation allegations, because knowing that the disinformation is coming from key people is itself important. And so those dynamics, I think, are really tricky and are underlying a lot of what's happening in these suits with Smartmatic and Dominion.
Well, one of the knee jerks in the suit that I thought stood out to me was that when the votes were finally tallied and Arizona's called and Georgia's called, Fox News called it for Joe Biden. They had anchors who were calling it for Joe Biden, and only afterwards, once Trump really lashed back and a lot of Trump supporters started going to Newsmax and OANN, did at least in these claims, did you start to see a shift in how they covered? And it seems almost like they did want. I mean, it was audience driven. That's absolutely true. And so I think part of what you're saying is that like newsworthiness sometimes becomes akin to just following audiences and in social media terms, following outrage, following what the narrative that's going to get kind of the most eyes. My confusion as someone in this point in time is this really new? I'm having trouble understanding, we talk about misinformation so often as this new phenomenon, but there must have been equal amounts of anxiety and unsureness at other points in time and in history and something akin to this, or maybe this is entirely new. I mean,
maybe before we jump in on that, I'll just add one other complication to the neutral reportage privilege and its application in these cases. One of the problems here is that I think that there are generally sensible policy reasons to recognize it, but it has been widely rejected by courts. And traditionally, it has not been applied in New York state courts. And both of these cases are being decided under New York state law. In one case, because it's pending in New York state court, and in the other case where it's pending in Delaware court, but parties have agreed that New York law applies. So I don't know that the neutral reportage privilege will be all that useful to Fox News. But interestingly, in a motion to dismiss that was filed yesterday, Dominion made yet another argument, and it was based not on, well, it included a neutral reportage argument, but it also included one based on the fair report privilege. And so what this motion to dismiss argues, it basically says that there are several constitutional doctrines under the First Amendment and then several doctrines under New York state law that, according to Fox, all lead to the same conclusion. And that is that it's reporting and commentary on what it characterizes as newsworthy allegations of public concern, but the sitting president and his legal team are not actionable. And so the three main arguments that are made in that motion to dismiss, number one, it is that truthfully reporting newsworthy allegations by a president and his team, that's not actionable. Two, it's that the media has complete protection to report and comment on allegations made in government proceedings. That is where I think not only a kind of a commentary privilege and opinion privilege is being argued, but also one under fair report. And then the last one is more explicitly an argument based on opinion and hyperbolic rhetoric around the allegations that were covered. And so the invocation of the fair report privilege is interesting for those who are following along and maybe less familiar with it. It can protect you from liability even if you publish something that turns out to be defamatory, as long as you relied on an official public document or a statement by a government official for the false information that you've quoted. And then you've got to go on and make clear that the document or the statement was your source. You have to get that accurate, and then you have to fairly use the source. And so again, this is kind of an in-run around the republication rule that would otherwise generally say that you are liable for the defamatory statements of others that you carry, even if you would do so in good faith. And so, here, it is, of course, a state law privilege. It varies a little bit from jurisdiction to jurisdiction, but it usually will apply where again, the source is this kind of official public document or statement on a matter of public concern, where the information is properly attributed, and then you fairly and accurately portrayed whatever it is that you're reporting on. So here, I think what could end up being kind of sticky is that while some of the statements are of course made by attorneys involved in litigation, and there the question under New York law is does the privilege extend to extrajudicial statements made in media interviews? And then some of the other statements, again, are, as we've discussed so far today, they were made by the talking heads themselves. And so, a host for Fox, making a statement on his or her own volition, completely unmoored from any public, or official document or statement, that is not going to be covered by, a fair report privilege, no matter how you would try to extend it. So I think that is going to be really interesting to see play out, not only the neutral reportage aspect, but also the fair report.
Yeah, Soraya, the narrative that you described is very much the pulsating narrative in Fox's, in Dominion's suit against Fox, right? It is, they are sort of building this, this argument that what happened here wasn't driven by mere curiosity about filings or mere desire to report what the president or his attorneys were up to, but rather, if you read the Dominion complaint, it sort of draws a narrative about post-election desire to boost ratings, a desire on the part of Fox, an anxiety on the part of Fox, seeing conservative reporters and conservative viewers gravitating to other organizations that were more supportive of these kinds of allegations and more supportive of Trump more generally, courting those viewers with shows and programming that elevated these sorts of falsehoods, and that that there was a sort of conscious decision-making on the part of Fox to engage in this catering to a loyal Trump base and to try to lure them back by elevating provably false claims about Smartmatic and Dominion. And once you sort of characterize it in that, that's plainly the face-off that we have here between Dominion's characterizations of what happened here and Fox's characterizations of what happened here. The Dominion complaint really does weave the narrative that you described, that there wasn't a news gathering motivation here, but instead a financial motivation, which is a really savvy characterization, right? When what you're trying to do is say, this is an entity that profited, that made a conscious decision to profit off of a falsehood, and now should have to bear the financial consequences of the harm that lie created.
That to me signals that they are aware that they may be they may be viewed as a public figure, that they're essentially really preparing for an actual malice claim. Is that your sense upon reading both of the complaints, that both Dominion and Smartmatic understand that that's what the high standard they're gonna have to meet?
I think that's right. I think they certainly know that that's, I certainly think that they know that it is a possibility, right? A distinct possibility that they are prominent business organizations that are involved in a significant matter of public concern, even prior to this controversy, right? They're in the business of elections, which is a fairly core prominent matter. Both of the complaints read to me like they are setting themselves up for the possibility of the need to prove knowing falsity or reckless disregard for the truth, and are weaving in a narrative that anticipates that possibility and that prepares evidence that suggests that that's the case.
And I would just want to say that it is important for us to scrutinize these voting companies, these election machinery companies. And so that tends to cast them more, the importance of us scrutinizing them tends to cast them more in the role of at least a limited purpose public figure for purposes of commenting on how their machinery was operating. One of the traditional hallmarks of whether someone is a public figure or not is, do they have access to the media to rebut the defamatory falsehoods against them? And one of the dangers here is when you have such a widespread systematic campaign to discredit your machinery, it's how does a company like Smartmatic or Dominion really effectively rebut the defamatory falsehoods that are brought against them just by accessing the media, and particularly without regard to these defamation suits?
Yeah, that's the place where Soraya's comments earlier about the changing media landscape might tie in, right? Because there is increased partisanship and echo chambers and these silos of information, and because we now see from this and from other episodes in the last couple of years, the sort of virality and speed with which these falsehoods can take hold, and the insularity, frankly, of our modern media habits in comparison to past patterns, all of those combine to make it arguably harder to dislodge media disseminated falsehood today. And that's a piece of the narrative that's being woven into these complaints. We certainly don't have it is not the case that our entire American history consists of neutral, transpartisan gatekeepers of information as a media model, right? There are plenty of eras in American history in which the media have been as partisan or more partisan than they are now. But we do have a complicated dynamic here in terms of baseline constitutional doctrine that was built in a different era. Sullivan itself was built in a very different era with a very different media model. I think that the Fox News dynamic, thinking about how you treat Lou Dobbs or Jeanine Pirro in a dynamic that is built on a different model, is absolutely at the forefront in these cases.
Well, can you just specify dynamic here? I'm just curious when you say that, because do you mean in part like political personalities, the connection between that and social media, the quickness with which a TV cable show can get cut and then spread across, the combination of that and partisanship? I mean, is it all together? Is it one particularly?
Yeah, no, I think it's all of those pieces, right? I think the fact that you can now roughly divide the country's news consumers into camps, right, who are receiving their information almost exclusively from Fox News, or as the Fox News Dominion complaint suggests, from Fox News, or they're going to seek someplace to the right of it to better reinforce the positions that they have, or are seeking it from other media sources, but not that they're seeking it from both, right? Because of really complicated media landscape. And I think the overlay of the spread of this information through social media channels just compounds that.
Absolutely. I will say that one of my, I have to write news stories frequently for First Amendment Watch, where frequently we write about slap suits. I'm often on the side, in some of these terms of the news organization who's defending themselves against libel suits. I know that all three of you have thought about this, and this is the framing of the event itself was what, is defamation a proper tool to regulate misinformation spread through the press? I want to be more specific about that question based on what you just brought up, RonNell. I am a little worried what it might say if Fox is the first one to essentially one to fall from actions like this. If it's the one to take the big blunt of a multiple billion-dollar lawsuits, how their viewers might react to the institution itself or to the legal system. If they really trusted that narrative, and if that further fuel the very problem you just described, which is the desire to essentially look elsewhere, to look continuously outside of an institution for your truth. RonNell, I'm definitely interested in what you're saying, but I see Lyrissa nodding her head, and Jonathan, I didn't have a chance.
I'll pass it to Lyrissa, but I will echo that I am a lot worried. If you're a little worried about that, and I am a lot worried. I'm a lot worried about the interplay of media press trustworthiness overall in this fuller dynamic. I think trustworthy sources of information on matters of public concern are core to a democracy, and that it ought to give us very significant pause anytime we are talking about trying to disincentivize the press using defamation law as a tool, right? That's the core notion that underlies all of New York Times versus Sullivan, is the major First Amendment risk that exists when what we're trying to do is disincentivize coverage in a particular way. And so a big piece of what's happening here is the overlap between really core questions of press trustworthiness, the use of defamation law as a deterrent of disinformation, but the boundaries of that, right? When deterrence becomes a chilling effect on speech about matters of public concern, or when the use of defamation law as a sort of blunt instrument turns out that maybe we need to be thinking really carefully about how the guardrails are built here, so that the future invocation of these principles doesn't have some of the practical effects that you've described and some of the legal effects that could emerge from it that could be quite dangerous to the relationship between the press and the people, and to the relationship between the law and the press.
Mm-hmm. Absolutely.
The danger arises partly from the fact, as it did back in 1964 in New York Times versus Sullivan, that the damages are potentially boundless. I mean, when you're talking about damages with billion with a B, that is a business ending set of damages. And so the problem is not the law, it's what you can collect should you be successful under the law. What I would say is there are some defamation cases out there that very well may be successful, brought by conservatives against the more liberal media. So there's a case by Sarah Palin versus the New York Times that I think the New York Times should be, quite nervous about. There's the other cases that Jonathan led us off with, where I think their case is brought merely to punish the speakers and don't have much chance of being successful in the long run. So, and that's one of the other problems with defamation, is it lends itself to a sort of weaponization to silence one's critics, because it's fairly easy to bring a defamation suit. It's very difficult to win one, but if you do win one, the potential for almost boundless damages is there at the other end.
Mm-hmm.
And Soraya, since you brought up slaps, it is worth noting that Fox has invoked the New York State anti-slap law, which is designed to deter these types of lawsuits. They come in various forms, of course. Libel actions are common ones, and plaintiffs normally don't file them to win on the merits. Often they are not trying to remedy some kind of actual harm. They're trying instead to retaliate or to send a message at frequently whatever cost and whether or not they win. Anti-slap laws generally allow for early dismissal of these types of actions, and the effect is to try to avert the high financial and emotional cost of litigation. New York's anti-slap law works that way, and it has been on the books for about 30 years. It was amended expand the scope of its protections for various forms of expression. New York used to have a very narrowly cabined anti-slap law. And so this actually could be kind of a test of the law's application to political speech, in the context of news and commentary. Right now, under that anti-slap law, Fox is arguing that Smartmatic and Dominion have to prove actual malice with clear and convincing evidence. Now, this is, of course, required in the First Amendment anyway, in the event that Smartmatic and Dominion would be found to be public figures of some sort. Because, and this is again, under the anti-slap law, because Fox has challenged public speech about election fraud, concerns what Fox characterizes as an issue of public interest. And so Fox is arguing that Smartmatic and Dominion can't do that, and that there is no or insufficient evidence of actual malice. And then, kind of speaking to the larger points here that both Lyrissa and RonNell were addressing, is libel law the right way to redress some of the harms that come from disinformation or misinformation? You consider what some of the harms are. It's reduction of voter knowledge. It's the corrosion of the public discourse. It makes it harder for us to arrive at agreement or consensus on kind of a common set of facts. It can contribute to political polarization, which can then in turn have the effect of eroding social stability or civil society. Political conspiracy theories have actually had the direct effect of harming individuals. We've regrettably seen that happen in recent years. And so I just am not fully convinced, though, that defamation law is the best tool to use to redress all of those problems. It may be a tool that we can use if you've got the right set of facts, and you may well have them here in the Smartmatic and Dominion cases. But I think more broadly, is libel law the answer to all disinformation, misinformation harms? I would think not. It was never meant to do that.
And here's the curious thing. It's the one thing that has seemingly had some impact on stemming the sort of fire hose of disinformation in the aftermath of the election. So it did, I mean, we should just lay down the marker. It already has had an impact. Lou Dobbs' show was canceled, and it was one of the highest rated shows on Fox Business. And all those stilted counter reports, made their way on because of the threat of defamation law on Newsmax and elsewhere. We saw footage of, people sort of interrupting guests and reading statements that sort of gave better factual information, all a result of the threat of a defamation suit. And so it's a really complicated space to try to think about. I think Jonathan's exactly right that we have real questions that we need to ask and answer about the risks that attend making defamation law do all of our heavy lifting in the space of disinformation, and particularly disinformation on elections and matters of public concern. And lots of questions about whether it's efficient or smart for that to be the tool that we use, and the risks that come in the other direction. But I think we can agree it does have an impact, right? Lyrissa's right that when it's billion with a B that's at stake and you're an $18 billion company, suddenly you think really carefully about what you broadcast in this space. And I think we're about to see that play out in some interesting ways.
I want to make sure we go to questions. Is everyone okay staying maybe 5 minutes extra just to make sure we get to some? Okay, if not, then let me know. Thank you so much. Please, everybody, feel free to add to the questions. I see a good handful here, but feel free to continue even in response to what is now talked about. The first question that I wanted to look at is by Grant Hopkins. What is the position of the court in terms of a reasonable viewer? Do the viewers have some burden to be reasonable, skeptical of their news source, and does this protect Fox? I'm thinking about the George Soros, Hugo Chavez, Clinton Foundation claims made by the media outlets.
Yeah, so the law typically does hypothesize a reasonable audience, reasonable viewer, reasonable listener, and that audience is, very suspicious. They think critically and carefully about what they hear. They don't just believe everything they read. I think in this instance, what might count against that are all the steps that the Smartmatic complaint in particular highlighted, where Fox did things to decrease that skepticism. They did things to emphasize the word evidence over and over. They said, don't listen to other sources, we're the source of truth. They emphasized in their introductions of the speakers that they're attorneys, and some of us know that attorneys are bound by ethics rules not to promote falsehoods. And so I think yes, and I think some of it could be discounted. A lot of defamation law depends on all of us like discounting what we hear so that it really doesn't damage the reputation of other people because we don't believe it. But I think in this instance, it's harder to argue that reasonable viewers viewing it over and over and over for a month with all of that extra baggage would have been suspicious enough for it not to cause harm to these companies. The other thing that I think was interesting here is in both complaints, the lawyers took pains to show the search analytics for their clients and how those search analytics proved that people were searching for Dominion and fraud or Smartmatic and fraud, and how it was suddenly there was a huge uptick in searches for this kind of information about them.
And adding to that, it's interesting that I think it was in March, it was Sidney Powell, and I can't remember if this was in an interview or in a court paper, but Sidney Powell made the comment that no reasonable person would take seriously the claims that she made. And of course,
that was in response to the Dominion suit.
Okay, is that right? Okay, yeah, and so this is kind of an echo of a case that Larissa's written about, the McDougal case against Fox News, in which Tucker Carlson, the court finds, cannot be taken seriously. That this is not somebody whose claims are to be taken literally, and therefore a defamation claim against what Tucker says fails, because the reasonable viewer goes into Tucker realizing that he is nothing more than a bloviator.
Mhm.
And so this kind of understanding of Fox News programs, I think is not only unintentionally hilarious in the case of Tucker Carlson, but is also very practically important for the purposes of determining whether something's opinion or fact.
Yeah, I almost wish that there could be some kind of, if you perceive that your show should not be taken seriously, I wish that there was just like something at the top, don't take me seriously, to start off with. Like, it's, how can you argue that as a person? I mean, what do we take seriously but the news? It seems it was that was just a shocking, or a lawyer representing the president. I'm sorry to get heated, but it was just
Yeah. Well, to be fair, Rachel Maddow also had a case like that where people said, oh, she's well known for just off the cuff and not factual. People really wouldn't believe that she was stating facts. So
that is true. Yeah.
But a disclaimer would help. You're absolutely right. A disclaimer would change everything.
I do have someone who has a specific question for you, Lyrissa. It's from Michael Balter, who says he's curious why you think the New York Times should be nervous about the Palin case. He's a reporter that's currently facing a defamation suit, $18 million for his Me Too reporting, and he considers I'm unsure based on the language whether he considers the one that's facing him a slap suit or the Palin a slap suit. But I think the latter could be too. Yeah.
So one of the reasons is that I'm thinking it's a little dangerous is because it was already sent back down to the trial court on appeal. And what they said was Sarah Palin had been accused of fostering the violent shooting in Arizona through her campaign publicity, that she caused the shooting in Arizona that affected Congressman Giffords. And so what they said was that the author of the piece should have known better, because in his own publication, there was information that would have refuted those claims. And that's true here in the Fox case for sure. There was information on other channels that would, on other shows that would have refuted the claims. But then the other thing that was potentially alarming was they said that because the reporter was the relative of a Democratic politician, that perhaps established some kind of targeting going along with knowing of the falsehood, and then you had a motive for targeting Sarah Palin in this way. So I don't know how it's going to come out, but I was a little surprised when they sent it back down to the trial court, meaning they didn't buy the press's argument that it was just opinion, and they didn't buy the argument that there was no knowledge of the falsity or reckless disregard of the falsity.
I seem to remember also that there was an email sent maybe between reporters that asked check it because they were unsure of whether it was true or not. And I think that was part of what the fact that they posted it, that they were conscious of it not being true to start out with, that undermined the idea that they were unaware of it, unaware of the statement. But but nonetheless, it certainly shows that defamation can be used, against more liberal publications. It can be used against more conservative publications. It just so happens that these cases wouldn't be so remarkable were it not for the quantum of damages. Mm-hmm.
Yeah, we might remind ourselves that one of the major concerns that press advocates had about Trump and the Trump administration, along with his characterizing them as fake news or enemy of the people, was his sort of constant desire to open up libel law and repeated assertions that he was going to sue various entities for defamation. He never sued them, he just loomed it over them as a mechanism to try to counter their factual reporting. And that is a different flavor, but of the same, same mix of ingredients, which is weaponizing defamation law in order to try to strike fear or to try to send messages or to try to counter information. And so the complex interrelationship between media trustworthiness, defamation, and the misuse of defamation as a tool, I think cuts in lots of directions and makes us want to be really careful as we move forward in thinking about the outcome of these cases.
So yeah, I think one of the guiding fears of reporting a false news story is losing the trust of your audience, not just a defamation lawsuit. And they should be kind of both in your head, and you should be concerned about both, but they should both. If you take away one, if you're just aware they will believe what I say because I'm telling them this is, and all that is left is a defamation suit, I mean, it becomes, I'm probably simplifying this, at the very least it's what I gathered, but it surely has large repercussions about how media works and why and how a news story is formed and what kind of steps are being taken. You know, we're getting close to time. There was someone who was interested in the larger historical question. I believe, like, what's new here, what's not. I'm trying to frame that to be more specific as a stepping stone. I think instead of, I apologize, I don't know if I can come up with a question for that, but for me as a person watching these cases, I'm curious, you know, you three, what are you going to be looking for as these continue to develop? What are the kinds of things that we should be paying attention to? Is something that I'm interested in. Jonathan, yeah, I'm being that you have a media column and that being that you are going to be writing about this probably, what are some things that you're going to be looking for?
Let's see, maybe I'll just begin by pointing out one thing I do think is kind of distinctive about these cases. And it's that both of them, the Dominion and Smartmatic cases, are ones in which the statements at issue, the offending statements, did not stem from, you know, one story. You know, Eric Wemple has written about this for the Washington Post, that, you know, what these claims stem from is a campaign, you know, that takes place over weeks. And, you know, Smartmatic, for example, has said that, you know, Fox anchors played along as guests, you know, that they provoked guests, you know, that they asked questions knowing what the answers would be, that, you know, that they endorsed the statements that were made or ratified them in some other way. So I think that, you know, then to get into the narrower question of what are some of the things I'm going to be keeping an eye on going forward, I think I'm most interested in some of the technical legal issues around the application of New York's new anti-SLAPP law, around the invocation of the neutral reportage privilege, to see if, you know, if they can make that work in New York state courts that generally have not been receptive to it. And then similarly, how in the world, you know, the fair report privilege might play out in this context. You know, I think what is perhaps less distinctive would be the arguments being made around opinion and hyperbolic language. You know, that is something that you more commonly see in defamation cases. But with facts like these, I think, again, it's going to be a little bit more interesting, more colorful to see what happens in neutral reportage, what happens in fair report.
Thank you. Sorry, I have one more question I do think is interesting if anyone wants to tackle it. If not, we can close up. Often in First Amendment rulings, considerations of the actual effects are considered. Do you think that the January 6th insurrection will come into play in any of these legal discussions? RonNell, I'm curious, you and I actually talked about this a bit. What do you think that's going to come into conversation?
I think it's already in the conversation, right? I think it's pulsating at the background of everything that's being said in all of these pleadings, right? Whenever stories are done about the Smartmatic suit and the Dominion suit, some of the B-roll footage that rolls where people are covering this reminds us that insurrectionists put on the Capitol door, murder the media, right? That it's sort of the complexity of the moment is there. I think Trump is not just sort of the elephant in the room in these cases. It's the underlying narrative of the, particularly the Dominion suit. I mean, the Smartmatic suit is unique in and of itself because Smartmatic literally wasn't even running any of these voting machines. They had one county in America for which they had a contract. So their underlying assertions about what was false about this are much more foundational. They're not, we didn't mismanage this, or we weren't associated with Hugo Chavez, although that was definitely a big piece of it. It was also step one, we're not even running the American ballot boxes right now. And so that piece of it, I think, is going to be interesting. But the Dominion suit very much, the complaint very much rises and falls on that cultural moment that you're describing, right? It's all bound up in the way that viewership was related to motivations for coverage, and was linked to those sort of expressions of support or astonishment by the anchors of those programs. And I think that it will be impossible for these suits to continue without ongoing reference to that moment, that really critical moment, both in our politics and in our media. And I think we're going to sort of have to continue to dissect this dialogue in that framework. We have no choice but to do so. It's animating everything that's going on here.
Wonderful. Thank you. I think that's a great ending. I want to thank you all again so much for taking a full hour and a little bit more to talk about this. I'm really looking forward to continuing to follow this. And thank you so much again for your time, and to all the attendees. Please, if you want to continue reading about these cases, you can go to our website, First Amendment Watch at .org, and follow our news stories. You can follow us on Twitter, First Amendment Watch at First Amendment Watch. Thank you again so much, and I hope you all have a great afternoon. Thanks, guys.
Thank you, Soraya.
Thank you.
Thank you.